Hello, I'm Danielle Barger, and I am a trust and estates attorney in San Diego, California with Barger and Batiste Law. I am giving you this information today to talk about one of the most common questions that I get from potential clients, and that is, why should I put my house in a trust? I could just add my child to the deed and make sure that if I pass away, the property will pass directly to that child. And I'm going to give you the reasons why that's not a great idea now. So let's say that you are a single woman, maybe you're divorced and you have one child, and your child is a wonderful child. He comes over and he sees you every weekend and he helps you with this grocery shopping, and he's a great person, doesn't have any issues with any sort of debt, nothing really to worry about. So you think, well, why do I need to go and see an attorney? Why do I need to spend the money to put together a trust? I will just add my son to the deed. And that deed would essentially be mom and son as joint tenants. Well, what does that mean? Joint tenancy is a way to take title with somebody. And when the title is taken, it will pass automatically to the survivor. So if mom and son are both on title, joint tenants, and mom dies, son gets the property. Easy. So mom thinks that that's the best way to go about it because it's very simple. Well, it's really not. There's a lot of downsides to putting your adult child on title, and so I want you to really rethink doing that. Here's the first one. The first one has to do with cost basis. So as I mentioned, I'm in California. Properties here are pretty pricey. So let's say that mom bought the property for $100,000. She bought this property a while ago, and now that property is worth $1 million. If she goes ahead and adds her son to the title as joint tenants, and then they both own it, and then she passes away, what happens to that cost basis? Okay, so let's recap. Mom bought the property for $100,000, and right now today it's worth $1 million. If she sold it today, she would be paying capital gains. Capital gains is an income tax on the growth of your investment. So she would be paying the difference between the date when she sold it and its value, $1 million, and the value when she got it, $100,000. So that difference is $900,000 to which she would be paying a capital gains tax on. Now, just in a full disclosure, of course, there are some exceptions. If mom were to sell her property and she's lived in it, she can get an exclusion of up to $250,000 when she sells it. If mom put a new roof on it, she gets credit for that. So what we're dealing with is a tax, capital gains, on the difference between the cost basis and the selling value. So let's say that mom passes away. And when mom passes away, the property is worth $1 million and it passes in trust to her adult son. Well, in the current state of the rules, when somebody passes away, we get a step up in cost basis. And so what that means is the day before she died, her cost basis was $100,000. But once she passed away, it got adjusted and her cost basis is now $1 million. So if the son were to sell the property shortly after mom passed away, then there's really no capital gains and thus no tax. Now, if the property were held as joint tenants, mom's share of the property is 1/2, and the step up in basis is only adjusted as to mom's half. So in that example, $100,000, the current value is $1 million, only the difference of $450,000 gets adjusted. And so if the son were going to sell the property shortly after mom died, there are capital gains. So that is a big reason why just adding your adult child to the deed is not a good way to go. What's another reason? Well, in this scenario, the kid was a great kid. Remember, I said that he came over and he visited mom and he was a wonderful kid, didn't have any financial issues and so forth. But let's say that there was a falling out and mom no longer wanted to leave the property to her son. She can't do that anymore because she's given away half of it. Many of my clients forget or don't realize that once they made a gift, that means it's gone. That means you can't control it any longer. So if mom changes her mind and wants to change her plan and give the house to somebody else, she can only give the half that she still has. If she were to ask her son to give it back, he may not want to do that. What if son goes off and gets married and then it doesn't work out and he gets a divorce? Now all of a sudden, mom's house is part of that son's divorce and potentially available to the divorcing spouse, maybe available to creditors if something were to happen. It just brings in a lot of unpleasant results. So don't add your adult child to your home unless you specifically talk to an attorney and you get advice specifically for you and your situation that says that's the right thing to do. And I say that because everybody has a different need and everyone should be talking to an estate attorney or some professional to make sure they're getting the right legal advice for them. So in most cases, that won't work. But you never know, there could be a situation where once we evaluate all the factors, it does work. And so be mindful of that. Don't try and do estate planning yourself. Don't try and add your kid to the title because you think you're going to save some money down the line. Go and see a professional, whether it's me or your current attorney or somebody else. It doesn't really matter. Just make sure that you're making those decisions on an educated basis so that you're getting the best advice for you and your situation. Thank you.